This meeting of the Senate Judiciary Committee will come to order. We have several items on today's agenda, and first we're going to vote on two judicial nominees whom we debated at the last meeting. Mustafa Kashibai to be U.S. District Judge for the District of Oregon, and Yumi Lee to be U.S. District Judge for the Northern District of California. The committee will then vote on my request for authorization for subpoenas related to the committee's investigation into the Supreme Court's ethics situation. I do not make this request for subpoenas lightly. I therefore would like to take a moment to outline the basis for the committee's investigation, the necessity for the subpoena, and how it clearly falls within prior committee precedent. Congress's oversight authority stems from its legislative power. As the Supreme Court has made clear, Congress's, quote, power of inquiry extends to, quote, any subject on which legislation could be had. And Congress has a long history of using its broad legislative authority to regulate the administration of the federal courts. This includes ethics legislation that applies to Supreme Court justices, such as Ethics in Government Act and the Federal Recusal Statute. Until this year, this uncontroversial proposition had broad bipartisan support. Let me give one example. In 2022, President Biden signed into law the Bipartisan Courthouse Ethics and Transparency Act, which was introduced by Senator Cornyn and Senator Coons, I believe, and co-sponsored by Senators Grassley, Cruz, and Kennedy. This bill requires federal judges, including Supreme Court justices, to periodically disclose certain securities transactions. To argue we have no constitutional authority to establish ethics standards for the court is to ignore this bipartisan action by this very same committee 1 year ago. Earlier this week, I spoke at length on the Senate floor about the Supreme Court's ethical challenges. So this morning, I'm not going to recount that history that prompted the committee to take up legislation to establish a binding code of conduct for the court, a measure offered by Senator Whitehouse. My Republican colleagues claim our legislative efforts are motivated by my disagreement with the court's recent controversial decisions. But I first asked Chief Justice Roberts to address the court's lack of an enforceable code of conduct 11 years ago. And I'm not the only one. In 2021, Ranking Member Graham co-authored a letter with Senator Whitehouse to Chief Justice Roberts about enhancing financial disclosure requirements for all federal judges and Supreme Court justices. The letter encouraged the court to adopt an ethics code and noted that legislation may be in order, quote, if the court does not address the issue itself. 11 years after my letter, the country is still waiting for a code of ethics on the Supreme Court, even after story about lavish gifts and luxury trips that Supreme Court justices have accepted and refused to disclose. In order to inform our legislative efforts to establish an effective code of conduct, Congress needs to understand the full scope of the court's ethical crisis. This is the legislative purpose for all the committee's inquiries in this matter, including the subpoena authorization I'm requesting today. While several individuals have cooperated with the committee's investigation, Leonard Leo has refused to cooperate. Harlan Crow has refused to provide a complete response. This should concern all of us. Defending Congress's legislative and oversight authority should transcend partisanship. To protect Congress's authority and advance the committee's efforts to implement an enforceable code of conduct for the Supreme Court, I am now pursuing compulsory process with respect to two individuals who refused to comply with this committee's oversight request for months. Contrast this with the request for a subpoena from the other side not that long ago in 2020 for the Crossfire Hurricane investigation. They provided the chair with a blanket authorization to subpoena more than 50 named persons and an unlimited number of unnamed persons. In that case, there had been no prior outreach to the vast majority of the individuals, and the Trump Justice Department was already voluntarily providing responsive information to the committee. Which brings me to my final point. I will be offering a manager's amendment that removes authorization to issue a subpoena to Robin Arkley. Although Mr. Arkley initially would not cooperate in responding to the committee's inquiries, earlier this week he provided informative response to our request and offered to have an affidavit attached to them as to the honesty of his disclosure. While I reserve the right to revisit the issue, I have decided that voting to authorize a subpoena to Mr. Arkley is not necessary at this time because of his cooperation. This underscores that the committee is not engaged in a vendetta against conservatives, that I'm not seeking this subpoena authorization to score political points. Leonard Leo and Harlan Crow are central players in the ethics challenge facing the court. Their baseless refusal to respond to the committee's valid inquiries prevent us from understanding the full scope of this issue. As chair of this committee, I cannot allow them to thwart congressional authority. For these reasons, I've asked the committee to authorize subpoenas with respect to Leonard Leo and Harlan Crow. This issue may be one of the most important the committee can consider. We have now reached a point, because of disclosures by the press about lavish gifts and trips to Supreme Court justices, where the reputation of the court is at an all-time low. It is within the power of the Chief Justice and his fellow justices to solve this problem before noon today, and they should have done it long ago. How can we possibly justify that out of the entire federal government, there are 9 individuals who are exempt from responsibility to disclose this sort of thing? When you take a look at the rules that govern even Congress on this matter, you can understand that this is part of the burden of public service that we willingly accept when we run for office. But this notion that they can just declare that they are in some royal status and don't have to be held accountable is impossible to justify. Why, if every federal judge is held to a standard of code of conduct and ethics, why do we exempt these 9 individuals? We shouldn't. Do we have the authority? We took it last year, and I mentioned earlier in legislation that was passed affecting the Supreme Court. This is a situation of great moment, and I think we should take it very seriously. I'm sure we will. I now turn to the Ranking Member Graham for opening remarks.
Thank you, Mr. Chairman. I think probably the best way to proceed is a lot of us will have comments about the underlying issue of subpoenaing these private citizens. I think I won't be the only one having concerns there. When you offer the subpoena, there'll be a bunch of amendments, and we got 2 judges to vote on. So I think probably the smart thing to do is for me to start the discussion about why we all oppose what you're doing. I don't know how the Supreme Court stands with the American people in terms of polling. I bet you they're better off than we are. Just about everybody in America has a better image with the American people than the Congress. You know, there's probably a lot of reasons for that, a lot of shared blame. All I can tell you is that you made this decision here to go after private individuals, go after the court in a way that we believe is trying to delegitimize not just Clarence Thomas, but the court in general. You've opened up Pandora's box, and you'll get a look into it. It's not very pretty. We could spend all of our time talking about what we would like to subpoena versus what you would like to subpoena. You're going to understand pretty soon today, there's a pent-up demand on our side for information. A lot of us would like to know a lot of things about what's going on in the Biden world, what's going on with Sotomayor selling her books, and I want to know how 240,000 people from 4 countries achieve parole when the law says it should be done on an individual basis with only 2 reasons to get in: urgent humanitarian need or substantial benefit to the country. See, all of us believe yesterday was a complete friggin' disaster in terms of Mayorkas' testimony. Most of us believe that DHS is openly, flagrantly violating the law, that they're not doing the analysis required by law. They're pencil whipping these things at best, ignoring it at worst. How could 240,000 people get an in-person interview, a determination to be made in a fiscal year coming from 4 countries? I don't believe that happened. I don't believe there is a process in place to follow the statutory requirements of granting parole in this country. And here's a question: of the people from the 4 countries in question, how many were denied parole? So the bottom line here is that we have a broken immigration system. We have a chance to do something on the border. I want to help Ukraine, I want to help Israel, but I also want to help our country. As to the subpoena request, It will be vigorously opposed by everybody over here, and you mentioned several of us wanting to, I'd like to see the court improve its situation, but I'm not going to pass a law. I think we're going too far by subpoenaing private citizens. You know where we're at. You chose to do this. I mean, Senator Whitehouse is a dear friend. We do a lot together. You picked a fight. I don't know why you want to. Maybe it's good. Maybe it's good politics. I don't know, but it's sure not good for this committee. I promise you, everything that was working well with the committee is now in jeopardy. We had a subpoenaed witness that I agreed to subpoena, a whistleblower, that was stunning testimony about the way Meta is run and the dangerous product not being changed when the company was on notice. There's a lot I'd like to do about that. I think people over here like to engage in that, but you chose this. Again, I don't know. I mean, I can't explain why you chose this fight. Things were going pretty well. We were voting on judges. None of us would have picked. I voted for most of them. Some people over here voted for others. Sort of the way it works. And now we're in a ditch. I mean, it's going to be a long day. We're going to get zero done. You're going to have a complete shit show. But if that's what you want, that's what you're going to get. So thanks.
Mr. Chairman, I seek recognition.
Senator Blackburn.
Thank you, Mr. Chairman. I think we all know what this is about, and you all have been after Justice Thomas. We are fully aware of this. And I think that the whole charade is truly disgusting. Now, if we go back to the Dobbs leak, and I'm one of those, I'd like to know who the leaker is, and I'd like to know why they did it. But since that leak, our Supreme Court justices, especially Thomas, Alito, Gorsuch, Kavanaugh, Barrett, they have been subjected to threats on their lives. Their families have been subjected to threats on their lives. And yet, this is what you and Senator Whitehouse are choosing to focus on, is a discrediting of the court. And we know what this is about. We should be talking about protections for the court. I think that it appears that what you're doing is you're going after them because right now you don't agree with some of the decisions that are coming out of the court. So instead of letting them exercise and fulfill their jobs, what they're required to do, what are you doing? You're going after a way to delegitimize the court as an institution. Tennesseans know this. We see it. But, you know, Senator Graham mentioned Justice Sotomayor. Now, this summer, what we learned was that over the years, her staff has pressured public institutions to buy her books. And these books and her book deals have earned her $4 million. And I haven't heard you mention that. None of you have mentioned that. You don't want to talk about that. Nor have you mentioned the fact that she refused to recuse herself from not one, but two copyright infringement cases concerning her book publisher. You clearly don't want to talk about that one either. So I have filed an amendment issuing a subpoena to Justice Sotomayor's staff who helped to sell her books, as well as to her book publisher, so we can fully understand the backstory of these deals. And since we're in the business of issuing subpoenas now, here are a few more that I've filed. A subpoena to Jeffrey Epstein's estate to provide the flight logs for his private plane, given the numerous allegations of human trafficking and sexual abuse surrounding Mr. Epstein. I think it is very important that we identify everybody that was on that plane and how many trips they took on that plane and the destinations to which they arrived. I've also filed a subpoena authorizing Secretary Becerra to come before this committee and explain to us how HHS and the Office of Refugee Resettlement has lost track of 85,000 children. In addition, I filed a subpoena to compel the Biden DOJ to provide all documentation about their disastrous decision to terminate the successful China initiative. That was a program that was critical to targeting and prosecuting Chinese spies in America. Next, we've got to get to the bottom of the far left's effort to take down President Trump. That's why I've filed a subpoena for all documents relating to any political donations and participation by Special Counsel Robert Mueller's staff. And let's talk about the two tiers of justice that we're all seeing in the Biden administration. This administration loves to talk about misinformation, but they clearly have the goal of censoring conservative speech online. In the latest example of this, DOJ, on behalf of the FTC, filed a privacy and securities practices suit against Twitter. So I think we need to get to the bottom of President Biden's efforts to silence Elon Musk. That's why I filed a subpoena to compel DOJ and the FTC to provide all documents related to the investigation of Elon Musk. So, Mr. Chairman, I think there are real issues that we should be talking about: social media and the way it's destroying our kids' lives. Wall Street Journal has an article in on this today. Our southern border is wide open. It is a vulnerability. The president's administration has lost track of 85,000 children. The world is on fire, but what you have chosen to do is to launch an assault on the legitimacy of the Supreme Court. If you want to take up our time and go there, Mr. Chairman, we can all go there. I think this is a sad day for this committee and for the confidence that the American people would like to have in our institution and in this prestigious committee.
Thank you, Senator. When I recognized you, I didn't know what subject you wished to speak to. As I announced at the beginning, the first thing we'll consider the two judicial nominations, then we will move to the subpoena, and I see people seeking further recognition on that issue. So after lengthy debate on these nominees at the last meeting, the question is...
Mr. Chairman, I want to speak on the judges.
Senator Cotton.
No, you go
Can you
ahead, Tom.
speak on the judges as well?
I want to speak on judges after Senator Cotton.
I'd like to speak today about the nomination of Mustafa Kasabai to be the district judge for the District of Oregon. We've seen some bad nominees from this administration, quite a few, in fact. There have been a few that have been reasonable and qualified. When those come up, I've voted in favor of them. That includes some judicial nominees from states where both senators are Democrats, believe it or not. Mr. Kasabai is not one of those reasonable nominees. He's not even one of the run-of-the-mill crazy left-wing nominees. He is uniquely unqualified to be a federal judge. First, as several others have mentioned, Mr. Kasabai wrote a law review article claiming that, quote, most intercourse is rape, end quote, and that, quote, heterosexual relations per se are infused with violence and control, end quote. If he were confirmed, I wonder whether someone accused of rape or any other sex crime, falsely or otherwise, would feel he or she could ever get a fair hearing in Mr. Kasabai's courtroom. Doesn't seem that Mr. Kasabai would actually care all that much whether someone being tried in his courtroom for a crime was guilty in any case. In a 2021 interview for the Oregon State Bar, again, 2021, not some youthful indiscretion 40 years ago, Mr. Cassaby said, quote, "We have to set aside conventional ideas of proof when we are dealing with the interpersonal work of equity, diversity, and inclusion. We have to set aside conventional ideas of proof." I want to be clear. He was talking specifically about how he views truth in the courtroom. In that same interview, he goes on to say, quote, "As a judge, I can appreciate the challenge of employing a different mode of understanding truth than that which most lawyers are accustomed to in our work," end quote, as a judge. Not as a human being, not as a father, not as a neighbor, but as a judge. A different mode for understanding truth than that which most of our lawyers are accustomed to in our work, like, say, the rules of evidence. As amazing as that statement is, it begs a question. If he feels that way about the modern racism and bigotry of the cultural Marxism labeled diversity, equity, and inclusion, what are the other areas where Mr. Cassaby doesn't like being bothered with pesky things like conventional ideas of proof? We could go on for hours about the problems with Mr. Cassaby's nomination, but I'll keep it brief because, unfortunately, I suspect my Democratic colleagues in this room are prepared to rubber stamp this grossly unqualified nominee. But there's one additional issue I would like to raise. I think most of you are familiar with the work of a left-wing grifter and charlatan who calls himself Ibram X. Kendi. Riding the wave of the BLM riots in 2020, Mr. Kendi, whose real name, by the way, is Ibram Henry Rogers, wrote a book on so-called anti-racism, which argues, in line with other critical race theory texts, for the destruction of Western civilization, capitalism, and our legal and political systems. According to Ibram Henry Rogers, America is fundamentally racist to its core. While the left was salivating over this new set of fancy labels for cultural Marxism, Ibram Henry Rogers was raking in tens of thousands of dollars per appearance to spend just a few minutes on Zoom calls, telling companies and nonprofits that they should all feel guilty because deep down they're racist. Put out a kid's book called The Anti-Racist Baby, trying to indoctrinate toddlers and kids to believe that they too are racist and everything around them is racist and their country is racist and it should all be torn down. Boston University even brought him on to create something called the Center for Anti-Racist Research, which received some $30 million as the university canceled all classes for a day to praise their new anti-racist leader as a saint in the pantheon of the left. They also took several silly political positions, such as by claiming that voter identification laws are, quote, an expressly anti-black form of state violence, end quote. But within a few years, it's all come crashing down with half of the staff of the Boston University Center fired and the rest transitioned to something called the fellowship model. Nobody's quite sure what happened to the millions of dollars that Ibram Henry Rogers received. It turns out that touting absurd ideas about race is, I guess, a lot easier than generating rigorous research to back it up. Maybe Senator Durbin could use his subpoena power to subpoena Boston University and Ibram Henry Rogers to investigate and expose this fraud. But coming back to Mr. Cassaby, he's a big fan of Ibram Henry Rogers, calling him, quote, an amazing historian. But he does have one complaint. He doesn't think it goes far enough. Mr. Cassaby himself said he would, quote, like to push some of Ibram's ideas a bit further. I don't know how much further one can push a radical ideology like this, but I do know that anyone who subscribes to it and anyone who wants to push it even further should not have a lifetime appointment on the federal courts to try.
Mr. Chairman,
Senator Kennedy?
Oh, yeah. Did she
Mr.
message
Chairman,
you
I'm
about
not
that?
sure I can do better than Senator Cotton, and I'll try not to repeat what he just said. Even a cursory examination of Mr. Cassabai's record and his testimony before this committee, I think demonstrates to most fair-minded Americans that he is from the loon wing of the American bar. Now, that is his right as an American. You're not free if you can't express yourself. You're not free if you can't say what's on your mind. But it is clear to me, based once again on an examination of his record and his testimony, that Mr. Cassabai is not qualified to be a federal judge because of his partiality. And I believe that his decisions will be filtered through his own political, social, and economic beliefs. Senator Cotton was very eloquent in giving you some specific examples. I want to give you one more. Mr. Cassabai is a magistrate. He issued an order, not an oral directive, but an order to all employees in his court, to all witnesses in his court, and to all lawyers in his court, that they address the court in a specific way and that they include their preference for pronouns, which, as we all know, is a reflection of one's thoughts about gender. This is a copy of the order. I think everyone has a copy. This is what his written order directs, for example, to his criminal docket clerk. Quote, I'm quoting the order, not the suggestion, the order. Before calling the first case, give the general instruction, quote within quote, I'd like counsel to introduce themselves, giving me your full name and your honorific, such as Ms., Mix, or Mr. Not Mrs., not Miss. And if your client will be making an appearance, I ask you to please introduce them to the court by giving me their full name and their honorific, such as Ms., Mix, or Mr. Mr. Cassabai says this is voluntary. That's not true, and he knows it. He intentionally misled this committee. He uses directives like, please be sure to give the honorific. You can read the document for yourself. I would feel the same way if Mr. Cassabai directed everyone in his court, and frankly, I could see him doing it, to stand up and give me your name and tell me about your race. I would feel the same way if Mr. Cassabai issued a directive to tell everyone in his courtroom, you have to give your name and your religion. And you have to give me your feelings about Israel. And you have to give me your details about your ethnicity. And you have to give me details about your sexuality. All of the things that bring the issue of partiality to the forefront, Mr. President. I'm appalled that President Biden nominated this gentleman. Now, again, when I asked Mr. Casaubon in committee, he said, oh, this is voluntary. Well, it's not. Here's the document. You can read it for yourself. And if he's confirmed, there will probably be more directives about how litigants and their lawyers and his court personnel have to address the court. But imagine, let's assume it is voluntary. Imagine you're a litigant whose property or liberty is at stake. And the man in front of you who is going to decide your fate tells you that he wants you to give your personal pronouns. And you don't want to do that. You'd rather not participate in that. You don't mind if others do it, but you personally don't want to do it. You've got to make a decision. Do I stick with my beliefs, or do I try to curry favor with this judge who's going to decide my freedom or make a decision about my freedom or my property? That is the classic definition of bias. And that, Mr. Chairman, will be why I'll be voting no on Mr. Casaubon. I want to emphasize again, I'm not criticizing his beliefs. He's entitled to those beliefs. If you want to be a member of the loon wing of the Bar Association, that is your right as an American. But it doesn't give you the right to bring that bias to the federal bench. Thank you for the time, Mr. Chairman.
Thank you, Senator Kennedy. Unfavorably reporting the nomination of Mustafa Casaubon. Senator Lee is recognized.
And to be clear, are we free to speak on both of these nominees or just Mr. Casaubon first?
It's your pleasure, whichever you wish.
Thank you. Thank you. All right, I'd like to, I'll be brief. Couple of things to point out on Judge Casaubon. This wasn't just a passing comment. In addition to the other things that have been said about this, in a 2023 speech earlier this year to the Oregon State Bar, he said DEI, diversity, equity, and inclusion, is the heart and soul of the court system. Can we say that? Yeah, I just did, and I say it proudly. So it's not just that he talked about that, and it's not just that he also said that we said this 2 years earlier in the Oregon State Bar Bulletin. As one of my colleagues mentioned, that he said, quote, "We have to set aside conventional ideas of proof when we're dealing with the interpersonal work of equity, diversity, and inclusion." These two things taken together. Look, there are a million things that you could identify as the heart and soul of our judicial system. The rule of law, hundreds of years of Anglo-American jurisprudential tradition, the Constitution, our laws, the people, the personnel, the attachment to the rule of law itself. You could identify the heart and soul of the judicial system in a number of different ways. If you're going to define it as consisting of diversity, equity, and inclusion, it raises some questions. Why? Why isn't it any of the other things we mentioned? Why isn't it the law itself? But then when you add to that his earlier statement that you have to set aside conventional ideas of proof when we're dealing with the interpersonal work of diversity, equity, and inclusion. Why? The judicial system is the one place where you don't want people departing from traditional ideas of how you establish the truth. So why there? Why is that fair? What does that say about his ability to be a fair and impartial jurist if he's confirmed to this position? Now, in response to Senator Kennedy's questions at the hearing, he backpedaled and he said, no, these are not obligatory. These are optional. It's an offer, not an obligation. Problem with that is we've got him on video speaking to the Oregon Bar saying the exact opposite. It is not voluntary. It is not optional, and you will be called on it. What does that say about his willingness to be fair and impartial to litigants and lawyers alike in his courtroom? All of this, together with his obsession with the writings of Ibram X. Kendi, which are themselves in so many ways some of the writings. He explained that he wanted to take Kendi's ideas even further, when many of those same ideas are incompatible with basic notions of due process, equal protection, and the rule of law. I've also got some concerns with Judge Lee. Although Judge Lee hasn't published her radical beliefs quite as prolifically as Judge Katsabai, she's no less radical. She authored an article in the Hastings Race and Poverty Law Journal in 2010, criticizing the methods that prisoners use to separate men and women. She doesn't like that prisons, quote, rely heavily on a dichotomous sex-based means of classification because, quote, prisoners are classified by their biological attributes rather than their gender identification. Yeah, there's some really good reasons why we have historically done that, reasons that have to do with the safety of prisoners, particularly the safety of female prisoners. It's well known in the prison system that you have different safety concerns in men's prisons than in women's prisons. Male prisoners behave differently than female prisoners. This is a significant issue. She previously served as a member of the Asian Law Caucus, and this is an organization that fought countless battles to preserve affirmative action in higher education. Race-based discrimination was recently found unconstitutional, appropriately so, by the Supreme Court of the United States in Students for Fair Admissions versus Harvard. And when Judge Lee was asked in her hearing before this committee if she agreed with the majority in Students for Fair Admissions or if she stood by the position of her former organization that fought defiantly to preserve race-based preferences in the admissions process, she didn't answer the question. Rather, she said that she would defer. Well, we can only hope. We should be able to do more than hope. I oppose both of these nominees, and I'll be voting against them. Thank you.
The question is on favorably reporting the nomination of Mustafa Taber Kasubi to be U.S. District Judge for the District of Oregon. The clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye by proxy.
Mr. Coons.
Aye by proxy.
Mr. Blumenthal.
Aye.
Ms. Sorono. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch. Ms. Butler. Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
No.
Mr. Hawley. Mr. Cotton.
No.
Mr. Kennedy.
No.
Mr. Tillis.
No.
Mrs. Blackburn.
No by proxy.
Chair Durbin.
Aye.
Chair
Senator,
Durbin, on this vote, the ayes
Senator
are
Coons.
11, the
Senator-
nays are 10.
Chairman Durbin, may I be recorded as if present, as an aye,
you'll be so recorded.
as present?
Would the clerk announce the results again, please?
Yes, on this vote, the ayes are 11, the nays are 10.
The nomination be favorably reported to the floor. Up next is Judge Yumi Lee, nominated to the U.S. District Court for the Northern District of California. Does anyone seek recognition to speak on her nomination? On favorably reporting the nomination of Yumi K. Lee to be U.S. District Judge for the Northern District of California, the clerk will call the roll.
Mr. Whitehouse.
Aye.
Ms. Klobuchar.
Aye by proxy.
Mr. Coons.
Aye.
Mr. Blumenthal.
Aye.
Ms. Sorono. Mr. Booker.
Aye.
Mr. Padilla.
Aye.
Mr. Ossoff.
Aye.
Mr. Welch.
Aye.
Ms. Butler. Mr. Graham.
No.
Mr. Grassley.
No.
Mr. Cornyn.
No.
Mr. Lee.
No.
Mr. Cruz.
No.
Mr. Hawley.
No.
Mr. Cotton. Mr. Kennedy.
No.
Mr.
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, on this vote, the ayes are 11, the nays are 10.
The nomination will be favorably reported to the floor. Anyone seek recognition? Senator Klobuchar?
Yes, I'd like to be recorded as present. I was doing questions in commerce via Zoom, so thank you
On both roll calls?
on both roll calls.
The senator from Minnesota will be so recorded. At this point, the Senate Judiciary Committee stands adjourned.